million in loans, and without almost anyone knowing about it. That was strange to this group of developers. And anyway, but that's what we're going to be talking about, is what happened with this development and this crazy attempt to turn our beautiful public waters into a private development. And we're going to start with Lauren's going to basically, for those of you who don't have a background in SLAPP suits, she's going to set the table up, explain to us what SLAPP suits are all about. Ben's going to take it from there. He's going to give us the background for this project and take us through the project itself, the science, and then what happened to him when he stood up and said, you know, from a scientific point of view, I don't think this is a good idea. What happened to him? And then after that, Whit is going to take it from the point where Ben got sued.
Spoiler alert.
And then after that, Adam and Rick are going to talk about the political and legal ramifications, basically what happened as a result of this lawsuit. It really is an amazing story. It's one that you'll be happy to hear. It's one that overjoyed me, and I'm glad we could present it to you. So, Lauren, take it away.
All right. So as Lance mentioned, I'm Lauren Regan. I'm the executive director and senior staff attorney at the Civil Liberties Defense Center. I'm a U of O law alum,
I
and
didn't say that in my introduction, and you did.
it's quite all right.
I just presumed everyone.
And we're based here in Eugene, Oregon. In addition to that, I am the legal working group lead for a national coalition called Protect the Protest, which is made up of about 40 national NGOs that came together in 2018 to basically form an all-for-one, one-for-all coalition to combat SLAPP suits that were filed at that time. It was Energy Transfer, which is Dakota Access Pipeline, sued every organization that ever showed its face in Standing Rock. And then there was another SLAPP suit, Resolute Forest Products, which is a Canadian logging company that sued Greenpeace, Stand, and a bunch of other activists for daring to call this logging company forest destroyers. That was the basis of that lawsuit. So one law firm represented both of those slappers, and it was a big firm called Kasowitz Benson Torres. We knew that this was a tactic that was being dusted off by the industry and by the lawyers that were representing oil and gas, logging, you know, all our enemies were kind of getting together under a couple of big law firms. And we formed a coalition to basically make it so that when one person was being slapped, all the rest of us would pick up their campaign and continue to make sure that the campaign was active, do media and comms for them, defend them in court. You know, there's basically a legal working group, comms and campaign working group, and a policy working group that is currently in the process of working in Washington, D.C. to get a federal anti-SLAPP statute passed right now, which I will talk a little more about. So that's me. CLDC. So I'm going to just run through these slides pretty quickly so we can get to the fun part of the story. First is just sort of, so SLAPP stands for Strategic Lawsuit Against Public Participation. And if you were to see a lawsuit, it doesn't have the word SLAPP on it anywhere. That's our word for it. It was actually a public interest lawyer that put that label on it. What it really looks like on paper is a civil lawsuit, meaning you don't go to jail for it. It's, you know, money, injunctions, you know, like all of those things. The most common version of a SLAPP suit is defamation, which is, you know, knowingly telling a lie about someone that causes economic harm. A lot of the other torts that we see in SLAPP cases, a tort is a specific kind of civil lawsuit. But most of the time it's going after things like economic interests, tortious interference with economic relations, or, those types of things that most of us as environmental or movement lawyers never do in our practices. The other thing that's kind of interesting and why I'm happy to see so many people here, for most movement aligned lawyers, we are either plaintiffs lawyers suing the government and suing the bad guys, or we are criminal defense lawyers defending activists. It's not very common that we are civil defense lawyers, and that can be intimidating for a lot of lawyers, and often is this is like your first time defending a case in civil land. I remember the first SLAPP I took, I was like looking at responsive pleadings from cases that I was the plaintiff's lawyer, and all of a sudden understanding why they filed this like long list of all of these weird defenses. I was like, oh, that's what they're doing. Got it. So a SLAPP lawsuit is a frivolous lawsuit, meaning it has no merit. You did nothing wrong to end up as a defendant in a SLAPP suit. A SLAPP suit is basically a form of legal harassment. It's dirty legal tricks, and it's basically meant to shut up your enemy, by intimidating them, by chilling them, by threatening that they're going to be in court. Sometimes it's actually filing lawsuits and trying to derail the momentum of a successful campaign, or an influential person. A SLAPP is normally the targeting of First Amendment protected speech. That's one of like the tests of what is a SLAPP, is that it has to be free speech. It has to actually be protected speech. Unprotected speech, which does include things like defamation, libel, and slander. Libel is written defamation, slander is spoken defamation. But again, the test for it, knowingly telling a lie, providing false information about someone or something that causes economic harm, meaning they have to prove that they lost money somehow as a result of that, defamatory speech. All right, so I already told you that part. So the primary focus of SLAPP lawsuits, if you end up in the crosshairs of SLAPP, the first thing to know is like part of the reason that this coalition that I mentioned started was to ensure that any movement participant, any activist, any progressive left organization, campaign, or individual that gets slapped will have a free lawyer. And the reason that we do this is because we know that one of the reasons that slappers slap is to suck money and resources out of our movement. And what is the way to deter them from that tactic? Making it very clear that our movement participants will not be losing resources as a result of that. They may lose sleep, you can't stop that from happening, but they will not be losing money. The other thing that the bad guys are intending is by targeting one group with a SLAPP lawsuit, they hope that other groups are going to be like, oh, they're kind of scary. They have a bad thing going on, so I don't want to associate with them because I don't want to get drawn into that naughtiness. And you have to really recognize that that is their intended goal, is to isolate campaigns, isolate organizations or individual actors from the rest of us. And so our repair for that is, as I mentioned at the beginning, if someone is slapped, if a campaign is slapped, our campaigns team will jump on the back of your campaign and help you sustain that campaign, amplify it, make sure that the bullies know that not only will they not be successful in deterring your campaign work, but now you've got 40 national organizations with big campaign teams that are going to start retweeting and re-amplifying all of that work. It will have the reverse consequence that the bullies think that it will have. Third is that they want to suck your money away out of your organization or scare you into thinking that. They normally in SLAPP lawsuits, you'll see at the bottom of it, it will say, and we demand $8.3 billion for calling us forest destroyers as a logging company on the boreal, forests in Canada. And so, number one, we all have a lot of experience in litigating these cases. We work collaboratively. We put all the brains on the table for your case to make sure that we will win. And to be frank, like not to amplify what Lance said at the beginning, but in my 25 years of defending SLAPP suits, we have yet to lose one. But what I want to say about that is, number one, this is not a common tactic. I don't want, when you're doing your threat assessments as campaigners, this is not something that happens every day. It is still rare when you think of how many of us there are in the US that are organizing campaign, activating, doing First Amendment stuff. There's a bazillion of us. And, right now, I think there's maybe like 2 to 4 SLAPP lawsuits going on the left that I know of. So it's not a super common thing. And because I told you that like a SLAPP is targeting First Amendment activity and it's frivolous, it's not too much of a clap that we've won all of them. They're bullshit, Yeah. So, if it is a true SLAPP, we should be winning them. A win for us is to win it fast and win it dirty, and what I mean by that is like, I don't want a discovery request to be sent across the line. Like as soon as I get that complaint that says we're suing you, my first response is going to be a motion to dismiss. And in 34 states, did I put this slide in? Yeah, let's see. In 34 states, there are state anti-SLAPP statutes in existence. That's basically a fast track statute. It says, if it smells like a SLAPP, you get to bring this quickety-quick motion to dismiss. No discovery requests, no nothing. If the court says, yep, it's First Amendment and it's a SLAPP, then it gets dismissed immediately. And then the other fun part is then we get to demand attorney fees and costs for the pleasure of doing business with the slapper. The significant part of that, though, is although the attorney fees and costs get paid, which we hope is a deterrent, our clients that just had months and months of sleepless nights do not get any compensation for the loss of, the emotional toll, the loss of maybe campaign motivation, maybe they had to like bring in an outside accountant to help straighten out the books, there are expenses and costs that organizations and activists very often have to incur when a SLAPP comes to town. In the states that don't have anti-SLAPP statutes, then we are bound by normal civil procedure rules. So then we will still file a motion to dismiss, but there's not this automatic trigger that says if it smells like a SLAPP, it goes away right away and discovery doesn't get to happen and stuff like that. One of the intentions of a lot of SLAPPs is to crawl up the nose of the SLAPP organization or campaign and attempt to do movement profiling, network profiling, psychological profiling. They don't really care much that Greenpeace called them forest destroyers. They're trying to figure out where's the funding coming from, who are the membership, where's the weak spots in this movement that they can target the next go around more successfully. They're trying to figure out, how do we pick targets? How do we build campaigns? Where can they stick their hands in and start trying to mess with our successes, basically? And so if it gets to the point where discovery is happening, it's kind of a loss to us, because that means they're in our underwear drawer where we didn't want them. And once that happens, it's definitely still a fight, but now the costs have just also shot through the roof, because they're going to be asking for like every Twitter your organization ever sent out, all of your Slack comms, your calendar entries, voice memos, all your Google Docs, all of the things they are going to start demanding with regard to the target of the SLAPP. So there's not a whole lot you can do to prevent a SLAPP from happening because it's a frivolous lawsuit brought because you were being successful. There are things, though, that you can do to help armor yourself in the event that you are frivolously sued. And so we're just going to kind of run through a couple of those. And there are a lot more details at protecttheprotest.org. I brought some brochures for that. Also, my organization, cldc.org, has a bunch of Know Your Rights webinars and other resources on our website, including some of the policies that I'm going to talk about in just a second. So number one, make sure that the things you are saying publicly are true and accurate. And for the most spicy of the things that you are going to say, especially if you know that your target or your flag, as the new term is litigious, you might want to take extra steps. So like, for instance, some of our organizational clients, for the juicy stuff, we'll have them put in footnotes, even on their website, in their publications, that has the source of where that spicy tidbit came from. It's a URL to a DOJ document, to a Forest Service document, whatever it is. The idea is that if you are showing sources and footnotes on the face of it, it might deter them from thinking that they have a hook to go on. Also, on the back end, if you're coming out with an annual report or you're putting a new website together or something like that, your final draft document should be fully footnoted with all your sources. And if you are using websites for that information, take a screenshot and save the screenshots with this final draft, just in case the website goes away. What you are doing is creating a folder of CYA, cover your ass. In the event you're sued, you've got this neat and tidy package of all the stuff and where you got it from. And it's one less thing to worry about. You've done everything you can at that point on that front. You've made sure that your stuff is corroborated. You've got good sources. You've saved those sources. You've done everything you can do at that point. Make sure, if you are an organization or a campaign, no matter how small or big, make sure that you've got a decent social media policy. Reposting someone else's defamatory statement is a separate act of defamation that you have just committed. So if I send out a tweet saying Lance has dead bodies in his basement and Whit reposts it, she's just joined me in defamation at that point. So, we kind of got in this habit of just reposting our allies' stuff without even like reading it and thinking about it. That's how a SLAPP suit goes from 3 defendants to 33 defendants sometimes. So just be careful in how you do that. As I mentioned, these are intended to derail the motivation of a campaign. So the worst thing that you can do is give the appearance that that tactic was successful. If you shut down the campaign, if you become a silent ghost, if all of a sudden nothing is coming out about that campaign, then your bullies see that as a successful expenditure of funds and energy for them, and you're going to see it a lot more. So it's really important that no matter what, even if you have to bring in outside allies to help sustain the burden of making it look like that campaign is still going, you really, really should do that. And then seek legal advice early and often. We, at the PTP and at CLDC, we do a lot of pre-publication review, which means we put our lawyer eyeballs on your written stuff before you put it out to the world. And we're happy to do that. It doesn't take that long. And we'd rather help you at the early stages than having to be heavily involved once you are sued, if that were to happen. Also, we do not want you to be chilled in your speech and your campaign. We want you to be as bold and, vehement as you want to be. And if the threat of slaps will limit you in that, and it would empower you to have a lawyer eyeball blessing on your thing, then we want to do that for you. And in fact, PTP in the next few months is going to have a webinar, a do-it-yourself pre-publication review training to teach you, your comm staff, whoever should attend, what we do when we are putting those lawyer eyeballs on your documents. And so stay tuned for that. And then for some of the bigger orgs, you might have insurance. And as individuals, if you own a home, your homeowner's insurance may actually provide you with a defense lawyer in the event that you are slapped. Now, this is like a good thing and a bad thing, because you will get an insurance defense lawyer who has no political alignment at all. Often I will co-counsel with these lawyers because like the big orgs, like Stand, for instance, I represent Stand, but they did have insurance when they got slapped. And their insurance said, you have to have our dump truck represent you. And that guy's first bit of advice was, shut up, take down your website, go to sleep, and I'll contact you when this lawsuit is over, type of thing. And that was not how it was going to go. And I think we really radicalized that defense lawyer. And ultimately we won that case. So if you've got insurance, great. You might want to look at the fine print on it. And there is never a downside to having more than one lawyer. And since we'll represent you for free, the defense law firms don't have to pay me or anything like that. So there's no skin off their nose if I do all the work and they bill, the insurance company at their normal rates. The other big thing is document destruction and retention policies. And these are ideally in writing. And even a one-person lone wolf activist can have themselves a document hygiene policy. This basically says every week, every 30 days, whatever your time frame, I'm going to go through and delete a bunch of stuff. My emails, my social media, drafts of documents, anything on, CryptPad or Google Docs that you no longer need should go away. The bottom line is, if a document doesn't exist, you don't have to worry about it getting stolen, subpoenaed, raided by the FBI, given over to your enemies, whatever it may be. We all tend to be document hoarders and email hoarders. And the more that you have, especially the stuff that you don't really know that you have anymore, is sort of a ticking time bomb. Because once you get a letter like this one, which is from Kasowitz, Benson, Torres, it says, notice of duty to maintain and preserve documents, materials, and information. Once you get this, I'm going to sue you notice, you are not allowed to delete a single thing. Now your document destruction policies are frozen. If you were to destroy stuff, it's called spoliation. It can be both a crime and a civil problem in a lawsuit. So, but if, they say, give me all your tweets, and your response is, my policy is that we get rid of all tweets once a week. So the only tweets I have to give you are from the last 7 days. That's how it goes. It is one small way that you can empower, that you can hold some power and maintain some control in a situation that you don't really control. You can't control being slapped or not because it's a frivolous lawsuit. But the things that you can control and the things that you can do are important and will provide you a feeling of confidence. Knowing that I've gotten rid of 6,000 draft strategic planning documents and the last flip chart of picking targets, that can go away once we've made those decisions, is important. And the other important part of that is you are only as strong as your weakest link, especially when you are working in coalition. if my organization has a policy that we're going to delete all these things, but Whit's organization doesn't, and we get sued and we've done everything we can, and we don't have a bunch of documents that now we're going to be forced to turn over that may do harm to the movement, but Whit's organization didn't do that, they're now going to be able to get them from her and her organization, and everything we did was just for naught. So especially when you're working in coalitions, and especially when you're working with newer or smaller groups that might not have capacity to know or have these things, this is one of the document destruction policies, which, like I said, are on the CLDC website, is one of the most important things that you can share with others. Any group that you are working with or are about to work with, one of the initial things, for a while, orgs got really into putting together MOUs or MOAs for everything. Memorandum of Understanding, Memorandum of Agreement. Big group agrees to do these things for little group will do these things for big group. Putting that stuff in writing can be problematic, not only in the event that you are slapped, but also in the event that there are RICO claims, racketeering claims. Big group giving money to little group to go do the things kind of looks like racketeering to some of our slap happy targets. We've never had a case where RICO has been successful against our movement yet. They've tried multiple times and they've been ridiculous attempts, but the courts have very clearly said that RICO is not this, and they've dismissed them. But again, by not having a paper trail, by keeping things clean and lean in the documentation realm, means that there is less stuff to worry about. And you want to remember that it's not just like, oh, will my org or will I get in trouble as a result of this document? You also need to be thinking about, like, what does this give to our enemies that they can use against the movement as a whole? What can they learn about the way we build campaigns, about the way we fund our organizations and our movement that could be harmful not only to us, but to everyone else? Which is why document destruction really should be a duty of all of us. And I really strongly suggest take a look at our draft policies, find something that you will actually do, because that's the key. You can have a 10-page tome of policies that are so much that no one's ever going to comply with it. And then it is a false sense of security. So you want to make sure that the policies that you adopt are policies that you and others will actually do, that it's pragmatically capable of happening, because you want to be able to rely on it as a safety net. You want to know if next week you get one of those letters, you and your comrades have done the stuff that you are expecting each other to do, and you want to hold each other accountable, because that is movement solidarity. Yeah, and then for lawyers in the room, obviously document destruction policies, well, and anybody that is running an NGO, tax documents, legal documents, there are retention rules to each of those that are different than just holding on to a tweet or a calendar entry. And on our website, we've got all the federal timeframes for how long you have to retain certain things. Yeah, so like I mentioned, once you are sued or once you're threatened to be sued, then you have to put everything in the freezer on what's called a litigation hold. And you have to preserve what you know or reasonably should know is relevant to the action, is reasonably calculated to lead to the discovery of admissible evidence, is reasonably likely to be requested during discovery, and or is the subject of a pending discovery request. Now, in one of the SLAPP cases that PTP has worked on, the enemy literally has the belief that as soon as an organization sends a trainer to a campaign to do an NVDA, they are on notice that they could be sued and they should be holding on to their stuff at that point, which of course is a ridiculous interpretation of this rule, but just kind of tells you, we come up with proactive things like destroy your stuff, And then they come up with an act of like, you have to save all your stuff as soon as you do the tiniest thing. And then if you are actually threatened with a lawsuit, you know, like I said, contact us right away. We'll help you get a lawyer, or we'll like, you know, help you gear up and make sure you've got all your parts together. You know, check your insurance company, make sure your policies are in place. And then, you know, let us help you come up with a communications plan, so that you can be both safe because you are being sued, but also not silent because that is the intent of your slapper. Like I mentioned, this is an actual notice of preservation request. And yeah, if you are sued, you need a lawyer, we'll help you with that. And as I mentioned, you know, SLAPP defense, if you've ever done a First Amendment case or a 1983 civil rights action, even as a plaintiff, you are very, very capable of doing a SLAPP defense case. If you are interested, we are always taking new lawyers into the coalition. We do trainings on a regular basis. We'd love to talk with you about coming and being a resource to the movement in the event that people are slapped. We also represent non-parties that get subpoenas in SLAPP. So they're not SLAPP themselves, but they were the adjacent group. And now there's a request for them to cough up all their stuff. We will find you a lawyer too for free, and we will file a motion to quash it up their orifices. It's very important to be really careful about settling a SLAPP lawsuit. It can create a very bad precedent. There might be a reason for that to happen, but in my 25 years, the only time that we had to settle a SLAPP is because the group that was slapped waited more than 30 days after being sued. And 30 days is normally the time frame that you have to file an anti-SLAPP motion. So by the time they contacted a lawyer, that time frame had passed. We asked the court in its discretion to let us file this anti-SLAPP motion. The judge said no. And so at that point, we ended up having to go to the table with TransCanada on the Keystone XL pipeline and negotiate a resolution. Which, just to say it, the resolution was that activists couldn't go within 150 feet of this pipeline construction route in Texas, which, you know, that was a loss, but they immediately just started like pounding those executives at every golf club, hotel, cigar bar. You know, they locked themselves down to podiums, you know, you name it. So the movement is nimble, and you know, I think we can always find ways to work around things like that. Oops. And I think that is, sorry. Okay, yeah. So this is what a SLAPP looks like, in case you've never seen one.
I think we're running a bit short on time, just
Okay,
to FYI.
Okay, go ahead. That's the end.
Oh, well, thanks for that last little picture. I want to see that picture again. Let's go back and see what the slap suit looked like.
There you go.
Ah, okay. Watch out for that, people.
Just looks like a lawsuit.
That's right. All right. Okay. Thanks, Lauren. Okay. This is awesome. Now you see why, you know, we have Lauren here. And wait, this is free?
Yeah.
No. There's no free, like really free.
Yes.
Why would anyone not come? That's what I did when we first started about this and contacted Lauren. Okay. Okay, now we all understand SLAPP suits. We're relieved that we can do something about them. But now we're going to let Ben tell us how SLAPP suits worked in his personal life. Ben, why don't you just take it away here?
Thanks a lot, Lance. And I just wanted to say for the record, I didn't know before accepting the position on this panel that Lance had bodies in his basement. I hadn't seen Lauren and Whit's tweets, but I'll go forward anyway. I'm going to give a very, very brief ecological introduction to Utah Lake. If you want more info, we put together a document at utahlake.byu.edu that goes into a lot more detail. But this is a picture of Utah Lake. It's an amazing ecosystem of a huge, expansive freshwater lake in the desert of Utah. Would you go to the next slide, Lance? So it's the largest freshwater lake in Utah, the third largest in the Western US. It has been the centerpiece of Utah Valley, culturally and ecologically, for centuries and millennia. So looking back at the indigenous peoples whose civilization centered around the lake, to the European settlers when they arrived in the 1800s, really important. And you have hopefully heard about the dire state of Great Salt Lake. Utah Lake is really central to that. It's the second largest tributary to Great Salt Lake, and the wetland complex that is around Utah Lake and Great Salt Lake is the largest inland wetland complex in the Western United States. Next slide. So it has had a rough go, as most lakes, rivers, and groundwater ecosystems have. It's experiencing a condition called eutrophication, or overnourishment. And so it does have harmful algal blooms, though we now know that those are less common in Utah Lake than in other water bodies throughout the West. We've made a whole set of changes, adding fish species to the lake, removing mollusks and other fish species. Would you click next one? And in the 1970s is when finally the lake ecosystem said enough is enough. And there was a shift from this large vegetation over to primarily algae and cyanobacteria. Next. The Clean Water Act and then the listing of one of the endemic species in Utah Lake as endangered under the Endangered Species Act started active restoration of the lake. And this really began in the 80s, 90s, and then the rubber hit the road, so to speak, in the early 2000s. This large coalition came together. They began removing the invasive species, working on habitat. I'll just point out in the bottom right there, they have removed 123 blue whales worth of Asian carp from the lake, just to give you a sense of the fecundity of the ecosystem, but also the scale of the ecological challenge of restoring the lake. Next slide. And this has really started to bear fruit. Utah Lake is an amazing ecological success story. The June sucker fish, a keystone fish species in the lake, only had a few hundred individuals in the 80s and 90s when it was listed. And the data, I just got the new 2022 data, and it's above 50,000 individuals of the fish that have now been observed in the lake. This has only happened 3 times in US history, where freshwater fish has been downlisted from endangered to threatened. And then on the on the biogeochemical side, the cyanobacterial blooms have decreased substantially following the worst time period in the 80s and 90s. And so we've seen a slow shift back to the native vegetation. Next slide. Here are some pictures of the inhabitants of the lake, 350 bird species, 20 fish species. And this is an Audubon graphic showing all of the places that those birds from the lake system are going at different parts of the year. Next slide. Some of the human uses of the lake. There are free hot springs around the lake, an active sailing and recreation community. And in fact, next slide, we even recently biked across the lake during the winter. It freezes, just an amazing ecosystem. So next slide. Then this happened. A company, LLC from Delaware, called Lake Restoration Solutions. I think we should pause there for a minute and say, they do deserve a prize for the name of their corporation. I mean, it's a beautiful noun salad of positive words. They came in with these claims that were completely counterfactual, saying that the lake is getting rapidly worse. If you don't do something drastic, within years, it's going to be a toxic mud puddle. They said that the current restoration efforts were not working. They were futile and pilot projects. They claimed that somehow the entire lake needed to be dredged and deepened, even though it's naturally a very shallow lake. It's only about 9 feet deep on average. They said that the natural characteristics of the lake, the evaporation from the lake and the waves in the lake were somehow bad things. And there's no way that the public could ever pay for its restoration. And so what we need to do is build islands and create a megacity in the lake. That's what the lake needs. That was their ecological diagnosis. Next slide. And they got a lot of political support for this. It was really a wake-up call for me and other researchers. In 2018, they got a law passed that said, if anyone will do quote unquote comprehensive restoration of the lake, then they can be given an undisclosed amount of quote unquote land within and around the lake. And this passed the Utah legislature with support from the left and the right. This was one of the surprises. The kind of Democrats in the state legislature from the Salt Lake Valley, they weren't kind of aware with what was going on with Utah Lake. Next slide. The governor's office similarly thought that we needed a total change in direction. Here are some quotes from Spencer Cox about the lake is a disaster. It's a trash lake. No one ever goes there. The state can't pay for restoration, and islands could be a great idea. So really, really a surprise. Next slide. We realized in the research community that there was the physical ecosystem where restoration was working, but there was another ecosystem that was more important. That's the ecosystem in the minds of our decision makers and even in the minds of the public, where they were experiencing a different thing. And so this was, we organized in earnest. Next slide. Okay, well, just a few more details because they're too juicy to pass up about the project. Here is the original drawing of what the islands would look like. They were being formed in the shape of arches from Utah's Arches National Park. And so they were going to use the image of one of Utah's wonders to deface the image of one of its other wonders, right? I mean, incredible. As Lance said, this was going to house 500,000 people. It would have been the largest land transfer from the people of Utah to a private corporation ever. But we've also looked, it likely would have been the largest giveaway of public lands in modern US history, right? Going back to a century or more. It was 30 times larger than the biggest nutrient dredging project ever completed. They claimed to have $6.5 billion. They received loan guarantees from the legislature. And even though they said this was all going to be privately funded, they were seeking almost $1 billion in loans from the EPA, right? These saviors from the private sector. Okay, next slide. So we began engaging in the way that we knew how to do as researchers. This is a panel that I served on, talking with the former leads on the project, the Parker brothers, and we thought that everything was going fine. It was an open discussion. We shared our critiques of the project. They responded, but then behind closed doors, there was a change in project leadership. Next slide. And a new team came on board, the Benson brothers, and they had a history of siphoning off public funds for politically motivated efforts. They've been involved in lobbying against the gray wolf and sage grouse and other endangered species. And they really did not appreciate being criticized and having external views on their project. Next slide. Because they had a real problem. They had been telling the public that this was the largest freshwater restoration project in the US. On the other hand, they were telling their investors that this was a development project, that they were going to be making tens or maybe hundreds of billions of dollars off of this free land that they were going to get from the people of Utah. Next. So they, for example, were telling the public that Dubai and this project have nothing to do in common, even though some of their engineers and others actually had experience and had worked on these Dubai projects. So they were telling their investors, this is the same team that brought those amazing islands in Dubai. Okay, next slide. And as we really got alarmed to learn that there were letters of support from the governor's office, the entire federal delegation, all of the senators and Congress people, and also one local city that were behind this. So this was a 9-alarm fire. We didn't know what to do. Next slide. And as scientists, we thought the most sexy and exciting thing we could do is to organize a symposium. That's for sure going to take them down, right? Everyone loves a symposium. You need to change your name, Lauren, protect the symposiums, right? So a typical scientific thing, we thought it was very successful. It actually built a coalition of researchers around the project. Next slide. And we signed a letter because a firmly worded letter is also known for stopping these. And something like 115 researchers, engineers, lawyers signed this letter of warning. There was fabulous participation from the indigenous communities we partnered. This is Mary Murdoch-Meyer and some of the elders from the Timpanogos Nation. We felt like it was moving in a good direction. We also thought it was going to take 5 or 10 years to stop this bad project. Next slide. We came up with these beautiful signs. Adam will tell you about this. Don't pave Utah Lake, because the developers had already gotten the websites for Save Utah Lake, Protect Utah Lake, right, and everything else that led to their materials. And right as we started to feel like we were getting some momentum, next slide, we in fact had several of the local cities that signed resolutions. We presented to them our concerns. They signed resolutions opposing the project. One, a state legislator, Kevin Stratton, amended that 2018 law to provide a little bit more oversight. And the Salt Lake and Utah Valley communities started working together on this. This was December of 2022, or sorry, December of 2021 and early January of 2022. And then right as we were going to have the first Utah Lake Summit, where both I would be presenting and the new leadership would be presenting, we got a wonderful care package. You click on, this is an image. I just want to bring your attention to this, the staple at the top, because that's one of the indicators that it's a slapped together lawsuit when they can't even put the staple in the right place. But we got this, it arrived the same day as this Utah Lake Summit, a really overt shot across the bow. And with that, I'll turn it over to the next presenter.
All right, so this is where I came in, and I've got some slides to talk about Utah's SLAPP statute. It was unique. So this year, the legislature changed it to bring it more in line with some of what Lauren was talking about. But before, it was structured in such a way that for us, we had to prove by clear and convincing evidence that the bad guys sued Ben with the intent to harass and silence him. So that put a pretty large burden on us right at the first. But I'll get into that a little bit later. There's the easiest. Okay, so Ben's told you about what was going on his side of the story, but we did do discovery, and I will get into that. So we got some documents from LRS about their strategy to manage Ben, and that is what they called it. So, you know, they were going to maybe have a meeting with him, and they decided that they needed to look at everything he was saying and try to find if they could find something that he said that was untrue, so that they could use that when BYU that they thought could maybe rein him in a little. That didn't work either. So again, they need to document any false statements that he's made and look at what legal action might be appropriate. It seemed very clear that they were hunting for some kind of falsities in order to bring this suit. That was their intent. You see this December 9th from one of their people. They saw Ben at a Utah Lake Commission meeting and decided, you know, we need to act. So this is the complaint. The timing of it was very significant. It was 4 days after they filed a U.S. Army Corps of Engineers application, which started a public comment period. One day, they filed it one day before the summit. They served Ben the day of the summit. And it was a week before the legislative session was about to start. So as Lauren was saying, these SLAPP statutes are meant to silence him. I think they very much hoped that Ben would get this and that he would not speak at the summit, that he would stop speaking out, and that he would, give up, or at least be quiet because of the fear of getting this. They claimed damages. They had 3 causes of action, $1 million for each one. They also, this I thought was really interesting. They tried to get a permanent injunction. At least they asked for a permanent injunction, keeping him from saying anything derogatory about their project, which just is wild. One thing, I didn't put this in the slide, but they also said, because I think that they had an inkling that this might be an unpopular lawsuit. So they put in there that they didn't need the money for themselves. They were going to donate any damages they got from Ben to a 501, a nonprofit organization for conservation. It probably would have been their own, but that's what they said. Anyway, ridiculous. So this is what they found, the allegedly defamatory statements. Ben had said that they did not have any PhD level scientists on their team. Turned out to be true, but that's what they sued him for. He said that they had shady foreign funding, ostensibly from Dubai, that they thought shady was defamatory, that they went public on the SEC. And this one that Ben said, project failure during design or permitting would leave the state of Utah with loan guarantees. That one is absolutely true. And so we're still not really sure why they sued him for that one. The project would privatize the lake bed and cover 1/5 of the lake and private islands. So true. And that he met with the developers, which, as Ben showed you, there were pictures of him meeting with the developers. So. Okay, so here into Utah's anti-SLAPP statute. So we were able, so our SLAPP statute, it was a bit of a mess. So it allowed us to file an answer, but supported with affidavits. And if any of you do litigate, you know that that's not common. And then we were allowed to file a motion for judgment on the pleadings, but then we could also attach affidavits to the motion for judgment on the pleadings. So it created this weird situation because normally judges, if you're going to present evidence, they want to treat it as a motion for summary judgment, which has a different standard. So it was a little odd here, but what we did was we did file an answer that was meant for public consumption. So it had a big part about Ben's credentials, the history of the lake, what Ben was doing, the history of the project. And then kind of at the end had the standard, we deny all of these things and here are affirmative defenses. So the statute also allowed us to countersue for damages. So, actually, sorry, I'm not quite there yet. So on the filing of a motion for judgment on the pleadings, all discovery is stayed. But then we had to prove again by clear and convincing evidence that the primary reason for filing the complaint was to interfere with his speech rights. So again, kind of a high burden for us to have without any discovery. And then we were able to countersue for costs and reasonable attorney fees. And there we had to prove that the lawsuit was commenced or continued without a substantial basis in fact and law. And then our statute, so it really does require us to have a little bit more going into it, but then it also provided for compensatory damages. But so that would be money to go to Ben for the, time and the emotional distress and all of that. So, but for there, we had to prove that the lawsuit was commenced or continued for the purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting his free speech. So this is kind of a rundown that skip. And then over all of that, we had to prove that his speech was proper participation in the process of government. Which they also, everything that Ben did was on its face directed at trying to get the legislature and the governor to stop this mess. And so that seemed very clear to us going into this. Utah's SLAPP statute is narrower than some because of this provision. His speech had to be directed to trying to convince either the legislative branch or the executive branch to do something. So Utah SLAPP statute has not been used very often because it's so narrow, but this case really fell squarely into that. So our defense, we filed this non-standard beautiful answer. We did a press conference the same day. So the other thing, this was an unpopular move in the public's eye. So their PR, it really did backfire on them. And we wanted to capitalize on that by really making this a big deal. The other thing is their project was still live, like the lake was still at risk. So we, turned the tables a bit to try to build up the unpopular opinions that they themselves had started by filing this suit. We also immediately, when we filed the answer, we served discovery on them because we wanted to see about their scientific credentials. We wanted to see their funding sources. And so we did that immediately. We filed these and they hated that. So eventually, we really we got in there. It was a big fight. They tried to not give us anything, but we kept pushing. The judge ordered them to give us stuff. And then eventually they sent us discovery requests. And originally the plan was as soon as we get discovery requests, because as Lauren said, we don't want to have to produce discovery. But the first set that they gave to us was really easy. It was basically, well, why do you think all of this is true? And we had provided most of that in our answer. And so we were just happy to provide all of the evidence that supported Ben's comments. But then eventually they wised up a bit and they sent a second set of discovery requests that was really invasive, that was asking for all of Ben's communications with everybody, with Conserve Utah Valley, with the legislative officers that he'd been working with, everything. So at that point, that was the starting line. And then we filed the anti-SLAPP motion for judgment on the pleadings, which immediately stayed discovery. And again, at that point, we had some ammunition to argue that their primary reason, so their intent, was to interfere with his free speech rights. And so we included these affidavits. We also, pretty shortly after that, we filed a motion for summary judgment on our counterclaims. So there we had to prove that there's no genuine dispute of material facts and that we are entitled to judgment as a matter of law. So we argued that LRS's claims had no substantial basis in fact or law, and that they had filed the lawsuit to harass Ben. So again, just to run through, because let's talk about what the judge found, because we had all kinds of evidence by then that we gained through discovery that we were able to prove. So the statement that Ben made about they didn't have any PhD scientists on their team, and yet they were calling themselves a restoration company, that is a problem. Turns out, shortly before they filed the lawsuit, they reached out to their engineering consultant firm and they asked, hey, this guy's saying we don't have any PhD consultants or people on our team. Can you send us a list of everybody who's been working on this with their credentials? And these people wrote back, so sorry, we don't have any PhD scientists. That doesn't happen during the permitting stage, that will happen later. And those guys sued him anyway on this. That's the very worst one. So the other thing, this foreign funding bit, the previous founders that Ben mentioned, there were the Parker brothers and now they're the Benson brothers. The Parker brothers were much more talkative. And they were telling people that they had global investors, foreign funding. Somebody asked in Dubai and they said, yes, Dubai. So this is a situation where Ben got his information from LRS, and granted, the landscape had changed. They were different people, but that's a defense to defamation. If you tell me that you have bodies in your basement and I say that, that's not defamation anymore because he consented to me saying that. That one, it's not. So I guess going back, the judge held at the summary judgment, and this just happened a month and a half ago. She held that yes, those first two ones, those are true or substantially true. And even if they were not, they're not defamatory. The same thing with this about them going public on the SEC. Yes, they did not go public, but they filed an SEC document where they raised $200,000 when they, had listed that they wanted way more. So true, substantially true, not defamatory. This one, I still, after all of those hearings, I don't know why they thought that wasn't true. So this one too, they tried to say that they weren't going to privatize the lake bed because the lake was still going to have a bed. They were just going to dredge it into islands and privatize that. So that clearly false and defamatory. Also, this 1/5 thing was so funny because their project did have 1/5 of the lake would be covered in islands, but they weren't all going to be private. Some of them were going to be public, open to the public, you might say. So that's, also true, substantially true, not defamatory. And then this one was silly. Ben had met with the developers. They tried to say, well, not the current ones, but whatever. So yeah, the judge ruled. So she ruled for us on this one, that the action was commenced or continued without a substantial basis in fact and law. These ones, because she had to find their intent, and of course they filed a declaration saying, well, that's not the reason we sued him. And so, it's not good evidence, but it is evidence that, the judge hesitated to find as a matter of law that they sued him for these purposes. She did hold that that his speech was proper participation in the process of government. So we're in an interesting situation now where, their claims are dead. The judge has said they have no substantial basis in fact or law, but technically they're still alive because we only moved to dismiss under this standard. So now we have two issues left in the case. What was their intent and how much money do they need to pay Ben? So we're going to go forward on that. And that's the end of my piece.
Awesome.
Great. Well, I can pick it up. I can pick it up.
Yeah, go ahead.
Oh, sorry,
Adam.
Lance.
Take it from here. Let us know how this shook out and what were the after effects of this now.
Yeah, absolutely. Well, let me start by providing just a little bit of context. As Lance mentioned earlier, I'm the executive director for Conserve Utah Valley, and we're a nonprofit, and we're focused on land and water conservation here in Utah. So when we heard that Utah Lake was potentially going to be developed with islands, that was something that was really concerning to us. So even before the SLAPP lawsuit, similar to some of the efforts Ben talked about earlier, we started responding and mobilizing people and putting together some strategy for how we could stop this project from happening. And this strategy that we put together was greatly energized actually by the SLAPP lawsuit. And that's what I want to talk a little bit about now, specifically how it energized our grassroots mobilizing efforts. It impacted our interactions with legislators, and then also how it led to some passing of legislation that was able to help slow down the Islands project. So we'll start with that first one, grassroots organizing. So the day that Ben received the SLAPP lawsuit, Conserve Utah Valley, we immediately started raising money. We were worried that Ben might have to handle those legal fees for himself, and we weren't sure what the process was going to be there. And luckily, Ray, Quinney, and Nebeker, Whit's firm, came in and volunteered to waive those fees. And so we had this pile of money that we had raised for Ben to use for legal fees, and he graciously donated that back to Conserve Utah Valley. And he said, use this money to help stop the project and to further conservation and restoration of Utah Lake. And that was really helpful for us to, one, start by having some resources when responding to this island project. So in addition to the financial benefit that that provided us as an organization, one thing that we quickly noticed is there was increased volunteer movement. At Conserve Utah Valley, we have action meetings, town halls, we host summits and service projects. And we've noticed that people started coming out of the woodworks that we'd never seen before to these events. And they were asking questions like, what can I do to help conservation around Utah Lake? people weren't even concerned just about the threat of the islands, but they also wanted to do something about restoration. So that was incredible to see. So capitalizing off of that momentum, we launched a Don't Pave Utah Lake initiative. And that consisted of a few different things from a website, but most outward visibly was these bright yellow Don't Pave Utah Lake signs that Ben showed earlier. And within a couple of months, we were able to distribute thousands and thousands of these signs all over Utah. And it would direct people to the website and would let them know that LRS, this Lake Restoration Solutions company, was a massive threat to Utah Lake. And these signs, I believe, led to tons of earned media that was able to help us just get people aware of what was going on, which then returned more volunteers and more people that were able to mobilize when we really needed to hit the road with it. In addition to that, one of the benefits that we saw was some goodwill developed between state agencies and ourselves. Previously, when trying to work with state agencies and communicate with them about this LRS project, they kind of held their cards close to their chest. They didn't want to give too much away, and they wanted to be very unbiased in which side they were approaching. But we saw that our conversations with them changed, where they were all of a sudden concerned that LRS was putting forth an inaccurate narrative of what was happening. And we were a platform that they could use to help put an accurate narrative out. And so we started to see individuals from state agencies willing to engage with the public in a different way that they weren't before, because it was just a stark contrast of how LRS's approach was compared to this activism that was going on. And that leads me kind of into the second thing that I want to talk about, and that's our interactions with legislators. We knew that in order to stop this project, it would require that we focus on a couple of the laws. One, the law that had made this all possible, which was the HB 272 that was referred to earlier. We would have to either get this bill repealed or amended or changed in some way to slow down the LRS train. And so we had been starting to approach legislators before this SLAPP lawsuit happened, and we found that a lot of them were resistant to meet with us about this issue. And that's likely because most of them had voted for this bill just a couple of years prior, and they didn't want to be seen as completely doing a 180 on a bill that they had voted for. But after the SLAPP lawsuit happened, we saw that the dialogue changed with state legislators. And rather than defending their decision to vote for this bill earlier, they started saying things like, oh, is that the group that sued the professor? Or is that the group that's picking on scientists? And it was a complete 180. Instead of LRS being a company that could come in and work on a restoration, it was a company that was picking on an individual for speaking his mind about a project. And we immediately saw lots of legislators not only start taking more of our meetings, but also inviting us to meetings to share our thoughts on what was happening. This eventually led to a close working relationship that developed with Representative Stratton. He's a Utah representative here in Utah County. And we asked for his help specifically. What can we do from a legislation standpoint to stop this development project? And we initially approached him with the idea to repeal HB 272, the bill that pretty much made this possible. And through some strategizing with him, he said there probably wouldn't be political appetite to repeal a bill like this right now. So we decided the best thing to do was try to amend that bill. And so that same year, he introduced a Utah Lake Amendment Bill, which amended that 272, which would heighten the requirements that needed to be met by LRS in order to take any of that lake bed, and made it not impossible, but much more difficult to be able to carry out their project. And that was a battle to get that bill through committee. And that's where a lot of these volunteers that I referred to earlier were really helpful. I think the first subcommittee meeting we had on that, we had around 80 or so people show up and come and speak. And that wouldn't have been possible without this SLAPP lawsuit, which brought so much attention to the issue. After it went through both committees and onto the floor, it passed with a pretty good majority. But that bill was ultimately one of the biggest blows that we were able to deal to LRS to slow down the project from happening. So in summary, we're definitely not happy. Conserve Utah Valley, this SLAPP lawsuit happened. No one should ever be restricted of their free speech. But we were able to work with Ben, with Whit, with state legislators and other environmental groups to really turn the narrative on its head and to be able to capitalize on this strategy in order to be able to slow the brakes on LRS's project. So with that, I'll turn the time over to Brigham to pick up there.
Thanks, Adam. And I won't, I think we got to leave a few minutes for questions. I think
Don't worry, take what you need, Brig. We got to hear from you.
That's great, but I'll try to make this short so we have a little bit of time, but we have, I think, 12 minutes left. Is that right, Lance?
Yeah,
Nothing here after this.
Okay.
that is true. So
The room
So-
is empty, so.
Here is, I think, the basic world shifted after Ben was sued. And I think in a large part it shifted because they wanted to shut Ben up by suing him. And it actually became just such an interest of the media that it gave him a giant megaphone that he was willing to use. So whereas before Ben was clamoring and having to hold symposia or whatever in order to maybe coax a reporter to hear him out, after this, he basically had an open mic, and anytime he had a hot take, it was there for him to use. Ben was pretty judicious with that, but I think the other thing that people saw is that of all of the people they could have sued, Ben was probably the worst person to choose because, I mean, the reason he was a threat is because he really does resonate with people in the area. He's, just not only very civil, but very kind. He's not just, a great advocate, but as you can hear, like he kind of went into this thinking he was part of a conversation and not necessarily as somebody railing against the system, right? I mean, he was sort of the, they were wise to fear him, but I think that they were very foolish to sue him given what ended up happening. But the thing that ended up, the most amazing thing to me is I had been doing some advising on the environmental law perspective to Conserve Utah Valley. And what I basically told them at the outset is like, look, the state is not going to take a stand on this project. The politics are stacked against you. That doesn't mean that we don't have good lawsuits. If we end up having to sue using state law, we can rely on something called the public trust doctrine. It's unlikely that that's going to really come into play until litigation time. But our best bet is to focus on federal law, and particularly this 404 permit application that they had sought. And I thought that we had some pretty good claims there. Just to kind of cut to the chase, and I think a lot of this may be, I mean, it's related to the lawsuit, but it's just also kind of their project untangling in front of themselves. As they started to lose major momentum, they lost political support. I don't know this at all. I'm completely speculating here, but I would imagine it was harder to do fundraising. That might be part of it, but they put together a pretty shoddy, when I say pretty shoddy, I mean unbelievably shoddy application for a 404 permit. And there was a lot of missing information. There were some substantive comments that were filed with the Corps. Ben was one of the foremost commenters, basically going line by line and talking about where there were inadequacies. But the other thing that was kind of going on is the politics of the state started to shift, and in quite a dramatic moment. I was at a public, I don't know if I was there. It is so ingrained in my memory that it's become such an important part. I can't even tell you if I was in the room or if I've just watched it online so many times. I feel like I was in the room. But the state, in a meeting in August, took the position in front of the legislature, the agency that's charged with administering the the saturated soils under the lake. It's called it. The name of the agency is called Forestry, Fire, and State Lands. Basically gave the legislature notice that they were inclined to reject the permit application because it violated the public trust doctrine. And I was just actually completely shocked. By October, the Army Corps of Engineers had rejected the application because they didn't provide sufficient detail. It doesn't mean that they couldn't go back and provide sufficient detail. And then later in October, the Department of Forestry, Fire, and State Lands denied the project application. That project, in doing so, it provided the most detailed, most significant explanation of what the public trust doctrine is and why it's important that the state had ever made up to that point. Up to that point, to the extent that the state itself was making comments about the public trust doctrine, it was after being sued by environmentalists, it was basically trying to sweep away the public trust doctrine. This was the very first time that the state had used the public trust doctrine in an offensive way to actually stop a project. The project applicants have sued the state. That litigation is ongoing. My guess is, and I really hope that they appeal this thing as much as they possibly can, because I think that this is going to be another example of how their litigation strategy just ends up blowing up in their face. The more that we can get the state on record on this, the better off I think we'll be. But that kind of gives you a brief summary of where we are. I think that we have about 5 minutes left, and why don't we just open up for questions? I'm sure folks probably have questions for all of the parties, so I'll shut it down here. Thanks.
Thanks, Big.
We can go over on the Zoom too. There's not a Zoom.
Oh, good. No good Zoom. Good.
So we will try to get out.
Okay, but we'll just break this up. But yeah, isn't this? Did I promise you a great story?
Yes.
And we had a great story. Watching this whole thing unfold in front of us, it was one of the most amazing experiences I've ever been a part of. I was very, very happy to be a part of it. In the words of Elvis Costello, the British singer-songwriter, it seemed like a good idea at the time, and now it's a brilliant mistake. And I'm sure that's what LRS is thinking right now. But I know. Okay, let's take the questions. I saw right back here.
Yeah, this is for Brig. Do you think that the state courts are likely to rule on the substance of the public trust doctrine and specifically embrace or reject the department's assessment of the scope of the doctrine?
Did you get that, Brig?
Yes, I heard that. I do think that's going to. I do think that the state will defend. I think that there's likely to be other interveners in the case that the state doesn't take that defense, but I am very optimistic. I mean, the opinion that the state wrote was not written by mere mortals. It was written by lawyers for sure. It was yeah. So I assume that the state was completely on board with this, but but a big part of this really could not have happened unless the politics changed as radically as it did. And I really credit the efforts of Conserve Utah Valley to engage with for the most part the Republican legislators that are in Utah Valley in a very civil, open-minded and friendly way, and Ben being the tip of the spear on this. So it was really the world has changed for the better in Utah.
We'll take the young woman in the orange there. That's my student. I'm just kidding. It's me.
Question for anyone really, but Lauren, you were saying these lawsuits don't occur that often. So just from hearing this, I kind of have this sense of what the perfect storm is, perhaps for a SLAPP suit to occur. But if there are, a few characteristics that are really common that you see when these do arise, what is that perfect storm where maybe these groups or people such as Ben can anticipate, this is probably gonna end up being a big problem.
Well, I don't think that on our side, we are thinking like this might be a big problem. I think that like at Standing Rock and with the Resolute case, the activists were winning in the court of public opinion. They were controlling the media narrative. They were growing support in advocacy and organizing efforts. And the way that the big corporations try to compete with that is by drafting up a complaint, filing it in a court of law with their narrative in the incubator of a courtroom, and then doing media along with that. So, you know, I don't think that anybody really predicted the ETP SLAPP suit, but they were like losing permits, you know, there were lots of other more pure environmental litigation that were going on in both of those, you know, in many of the situations where we see SLAPPs, and when they start feeling like they're losing, then we see this sort of desperate knee-jerk reaction as a SLAPP, as almost like a media event, but also like they have bazillions of dollars and a ton of staff working 40 hours a week, and we are mostly volunteers. And, you know, that imbalance of power is another, you know, part of the dynamic that we see a lot, or perceived imbalance of power.
Yeah.
I have a procedural question for Whitney. You know, there's a deadline in most states, I think, to file a SLAPP motion. So how did you get discovery?
We didn't have a deadline.
Wow.
I know, our statute was so unique.
Okay.
And that's a kind word for it. The new one that they have instituted now, it does have a deadline. So hope, I mean,
But
you know,
but the defendant no longer has a burden of.
right,
Okay.
yeah, so they've changed the burden of proof, so. Yeah, the structure has changed a lot. I think overall it will be much better for defendants. This statute worked well in our situation because the project was ongoing. And I think that we were really able to make this lawsuit a real thorn in their side, so.
Was that changed in part because of this lawsuit?
No, apparently they were working on it.
Okay.
'Cause it was, I mean, it was like a Frankenstein monster.
Yeah.
statute, you know, so they were working on it.
Okay. Didn't hurt it though.
And
Yeah.
most SLAPP cases that wind their way through courts are actually like bad Yelp reviews. But I said it's few for our world,
Yeah.
but like there are a lot of SLAPPs happening between X's and like, you know, bad Yelp reviews, and that's probably what was going through the legal system that caused them to maybe start looking at the changes.
Can I just
Yes.
say one other thing, that, you know, one major shift here was Whit being able to stand up and say that Ben is going to be defended. I mean, Ben didn't sit down even at the morning he got served. He still went to the forum and still gave his bit. But, you know, I think that Whit deserves just a ton of credit for the success that we're seeing here. And we're so grateful for her.
Thank you.
Good job, yes.
Great talk. I'm curious about the costs. I come from British Columbia, Canada, and we have a section of public participation statute that allows for full indemnity costs to be awarded to a defendant of a SLAPP suit. It sounds like you didn't get that in this case with Ben because of the, I guess, the limitation.
No, we did. So the judge's ruling, so allows for fees and costs, to be reimbursed. We actually just filed our motion for attorney fees to date. Because the fact is their claims are still live. So technically they just send my invoices to them until we're done. So yeah, fees and costs, they will be reimbursing them.
And is that typical in what you see under SLAPP?
Yeah, if they're going to reimburse attorney fees, costs are usually rolled up into that. Costs are much smaller usually, so.
Costs are like filing fees or out-of-pocket costs for the litigation itself, basically.
Yeah.
Oh, sorry, when I reference cost, I guess the different.
You mean
Okay.
compensatory damage.
For any expenses total expenses they would have, including attorneys.
Yes, so attorney, we usually call them different, so it's attorney fees and cost, we split them out, but all of those wrapped in together are what LRS has to pay to us based on the judge's ruling that she already gave. So the damages to Ben, so his, like all of Ben's time and his emotional distress, that's a separate part of the statute, so we're still gonna need to litigate that.
And that second part, which that she just mentioned, is not normally covered in an anti-SLAPP statute. The attorney fees and costs, yes. Any money to the defendant for their pain and suffering, no.
And is that a higher bar to meet?
It is, because I have to prove the bad guy's intent, so we're gonna
Yes.
need a jury. So
Yeah, you know,
I think there was an agreement.
Yes.
What's the intersection with the states that have SLAPP or anti-SLAPP lawsuits? What's the intersection with Rule 11? Or is there any?
So, yeah, I mean, Rule 11 is such a low bar that, I mean, I think that maybe we could have brought you a Rule 11 and done the whole Rule 11 procedure early on. But judges are so hesitant to use that. And LRS's lawyer, the lawyer that they hired to represent them on this, he's surprisingly, like, really well respected in the bar, or was. So I mean, that would have been a hard sell for most Utah judges.
Yeah, and what about like the repeat offenders? Because you guys mentioned,
Vexatious.
Lauren, you were mentioning that like certain large law firms are starting to take on these clients and churning these things out. You know, looking at sort of a pattern of practice and using Rule 11 to not just get at fees, but to get at not necessarily bar licenses, but to really chill those attorneys from bringing things that are the standard is that it's a frivolous claim. That's meeting by definition Rule 11.
So I will say, I looked at this a little bit. I think that Utah statute could have potentially allowed me to sue the lawyers too. And potentially LRS's officers personally. So, and some statutes allow that even like in the words of the statute. So
California has a slap back statute, and we actually have a lawsuit against the law firm that filed the frivolous slap.
Yeah.
But that extra part of proving that the lawyers were not only completely unreasonable, but also did it for malice is what the courts hate. They do not like saying that lawyers did things for malice.
Yes.
How does this work in a state without an anti-SLAPP statute? You had Minnesota in red up on your map, but the Supreme Court has gutted our anti-SLAPP statute.
Yeah, and Washington State too. When there's not an anti-SLAPP statute, then you're dealing with Rule 11, you know, you're dealing with regular civil procedure, and there's not that freeze on discovery potentially. And the same also is true for some of the federal district courts. Like we see slappers forum shopping, and they will file their slap in a federal court that does not allow the state anti-SLAPP statute to be used in federal court. We actually have a lot of concern right now that there are cases on their way to the US Supreme Court regarding whether or not state anti-SLAPP statutes will be permitted in federal courts, which is why we are racing to get this federal anti-SLAPP statute passed in Congress right now.
Heather.
Hi, so my name is Malia. I'm from Utah. I'm an attorney there. I live in Austin. And my question is about, for the virtual contingency, is can you speak to the cultural aspects of all of you being from Utah Valley and associated with BYU, as opposed to from Salt Lake Valley and associated with the U? Brigham, you might be the best person to speak to this, but you know, you are all white men who have access to the legislature in Utah more than anybody else in Utah. Can you speak to that aspect of this case?
You want to take that, Brigham? Or
Yeah, I mean, I can. I think that probably Adam or Ben, I'd like to hear what they have to say too.
yeah.
What I have to say about this is, this really had to go down differently than, you know, I think that a big part, and Adam can probably speak to this, and I mean, it had to seem like this wasn't the typical environmental crowd for from Salt Lake County in order to get access to the legislators and to move the department. I'll let the other two kind of speak to this and say we're more involved with that though.
Yeah, I think two things that I'd like to call out. I think that one, and Brigham alluded to this, is we had a unique approach where our approach was a total collaboration. It wasn't like offensive, is like we didn't want to butt heads with legislators and make enemies out of them, but we wanted to find common ground as much as we can. And I think that kind of gave us a bit of a different foot in the door that we maybe wouldn't have if we had been more offensive. I think another thing that we did strategically that I think was helpful is what we did is we put together a Utah Conservation Coalition. And this was a kind of like a task force that met every 1 or 2 weeks to discuss what was going on with Utah Lake. And we included more people than just those in Utah Valley, us white males, but we had Native American tribes represented. We had just landowners represented, farmers, we had environmental groups. We also invited city councilors and county commissioners. And so we really were able to embody this persona of like, we're all of Utah. We're not just an environmental group that's advocating against this. And I think that was really helpful in our response strategy.
And I think I'd speak, like, as far as public sentiment goes, I do think that the fact that Ben is who he is, not only like a very charming and well, you know, like well-educated person, but he, the fact that he is a BYU professor, I think that was huge. Because like you get kind of like he pulled in people who maybe otherwise wouldn't really care about environmental issues so much. And where you have this crossover of this is an environmental issue, but is also a free speech issue. And then LRS chose to sue Ben in Salt Lake County, although Ben, you know, was in Utah County, he lives in Utah County. And so I think that also was maybe a mistake for them because, you know, the fact that he's a BYU professor maybe doesn't hold quite the same weight in Salt Lake County. But, you know, Ben has all of these different things to commend him to the population of Utah. And he was, you know, he's a very popular figure in this story. And that I think that's definitely an advantage in the way we were able to turn the media.
It's interesting. Utah has a history, largely conservative, as we all know, but they have a history of turning on any conservative who tries to violate someone's First Amendment rights or tries to belittle or mock someone. We saw that in an election about 20 years ago where the Republican candidate was polling at 95% until he posted a picture in the newspaper of his family. This is my family. And the Democratic candidate was divorced, all alone, you know, and he said, here's, you know, Orton's family. Within a week, the electorate turned against him, and we had our first Democratic representative, I think, I don't know, half a century, ever, maybe, you know. And so I think that was a big part of it. And the team recognized that we will capitalize on conservatives, you know, justifiable protection of First Amendment rights here. And so I think that was good. So, but Ben ended up being great for so many reasons to all of us here. Thanks, Ben, if I haven't said that a million times. Yes.
Why were the Democrats in favor of it originally? What reason did they get jobs, or they thought it was a restoration project, or?
Yeah,
That's a good question. Go ahead, Ben.
yeah, the act was called the Utah Lake Restoration Act. And that view of Utah Lake being irreparably harmed was quite widespread. So the state agencies that have been overseeing restoration, they don't have budget. And in fact, sometimes they are legally prohibited from lobbying or sharing their successes. And so there was a complete lack of understanding of the ecosystem. And
one more?
Yeah, one more, and then we'll
Supreme Court legitimacy. Is this, if these guys keep ruling, if the trend moves toward, you know, not, you know, not using, not, you know what I'm saying?
Not allowing state court anti-SLAPP laws in federal courts.
Yeah. Is that an avenue that you would
pursue or?
Oh, no, I want to stay away from that Supreme Court. They are not doing anything good for anyone at this point in time. I mean, I don't think it would necessarily go well for us. So that's why the far right and the industries are gonna be pushing it toward the court because it's their court now.
So isn't that like a third world country in a way? That
Sure.
That's what we're entering into. Thank you all for coming.
Thank you.
Thank you all for having
There's
us.
brochures here, and stickers, if anyone wants to protect the protest stuff, there's also a table. If you don't come get them here, you can come get them there.
We're out.